Hi, everybody. This is Jeff Fowler with the Apartment Owners Association, and we're going to be going over 10 mistakes to avoid when you're filing that eviction notice, filing that eviction notice. The only problem is that there's probably more than 10 mistakes you can make, but nonetheless, AOA is dedicated to your real estate success, and that's exactly why we are doing these. So whether you're catching this live or after the fact, we hope that you get to this information, and we hope you share this information with your other friends that may own rental property. And just want to mention that we do have the trade show was awesome. If you're able to go, that's great. We're almost done producing the recordings from that, and we will be selling the recordings from the trade show for $299 on the website there's a forms order page on the website. You could also get it there. So anyway, so that's going to happen. That's going to be up pretty soon. So again, thanks for coming. We had like literally, you guys gave over 1,000 unwrapped brand new toys that Union Rescue Mission's going to use. And so thank you again for being generous with that and helping. You're going to help kids that really don't have the same opportunities that other kids might have. So we're really happy to help that way. People think that landlords are cheap and mean, and where that really proves totally the opposite. And anyway, so I'm proud of you guys for that, and I'm glad that we are family here. So anyway, there's a membership orientation next week that we'll do. It's not on the schedule yet, but it'll be up there today or tomorrow. We'll have that up there, and it'll be just how you can maximize your AOA membership. So basically a membership orientation. I know there's a lot of new members just from the trade show, and I know a lot of people renewed their membership. So welcome back for sure. And we had a lot of great content on YouTube lately. So please check out YouTube and just type in AOA USA, just like our website. It's aoausa.com. So just type in AOA USA and you'll see our channel. Our speaker today, Dennis Block, he had a security deposit crash course that he did. We had a property management company CEO talk about 10 ways to keep renters happy. All these things, that's just the tip of the iceberg. Lots of good stuff. And then also just do want to mention in September, we're going to be having some of our in-person seminars. So San Diego at the Marina Village, there'll be termination notices and the move out process, and similar topic in Pasadena and Buena Park. And so just check the website. In October, Fremont, Santa Clara, Sherman Oaks. So we're hitting different cities, and hopefully you'll be able to catch those different seminars that we have going on. And for those of you that are members, whether you picked up that free 6-month membership at the trade show, or whether you just have a regular membership, the seminars are free for you as a member, and non-members pay $39 for those. And anyway, welcome to those of you that are in the Zoom call. And if you're watching on YouTube, you can get in on the Zoom call. And anyway, so like I prioritize the questions that are there in the Zoom first. And it's just kind of a fun way to interact with each other. And yeah, we're going to launch into this now. Our speaker today, he's done over 300,000 evictions, 45 plus years of experience. Dennis, what do you have? 29 attorneys on staff? Where are you at?
29.
29. If you guys aren't reading his legal Q&A, you definitely need to be doing that. It's in the AOA magazine every month, and you always come up with good stuff on that one. So Dennis, you want to take it away here?
I am going to take it away. Thank you very much, Jeff, for putting on these webinars. Again, it's the knowledge imparted to the landlord community is so valuable. They have so many new rules and regulations that it's it's really all encompassing. So my hat's off to the Apartment Owners Association, and I'm happy to contribute whenever I can to this great association. And I do also recommend if you're not a member, become one because the fees are minuscule and what you get back is so great. So the topic today is 10 mistakes to avoid when filing an eviction notice. Actually, Jeff, you came up with that title, but it should have been like 1,000 mistakes to
I know, I
avoid.
was going to say probably pretty easy to come up with 10, huh?
Yeah. So the reality is, and before I go into the topic, is that these rules and that are required by landlords in order to regain their property when there's been a true violation of the rental agreement are so varied, and it's really the intent of the politicians to make you lose. That's what these rules are all for. It's to give tenants an unfair advantage, allow tenants to game the system, and any small little error results in a landlord losing a case, and then, of course, having to start all over again, which means another 3, 4 months worth of lost rent that in most instances is not going to be recovered. So you have to take what I'm saying with the thought process that in truth, and when you hear this seminar today, I think what you should really think is that even for a simple non-payment of rent notice, most of the times when clients serve their own, then when they come to us, we're just going to have to redo it. So you might as well come to the law firm before even serving a notice. And unfortunately, back in the day, it was so simple to fill out a 3-day notice. You filled it out, the tenant didn't pay, you filed the lawsuit. Back in the day, actually, I had many landlords that I knew would file their own eviction lawsuits and they would do a reasonable job. Well, that's not the case now. The case now is based on these requirements, which I'm going to go over some of them. You're going to find that it's almost impossible to find. So let's go over some of the basics. We're going to talk about a notice to pay rent or quit first. And of course, in the notice to pay rent or quit, you only want to ask for rent and nothing else. You don't want to ask for late charges or parking charges or any other charge that you have separately designated in the rental agreement. Or, for example, even late charges. You can only ask for rent and rent only. That's why they call it a notice to pay rent or quit. And also, there's a little known law that you cannot ask for rent more than 1 year old. So and we see this all the time where landlords don't collect rent for more than a year. I know it's insane, but we see that at least a couple of times a week in our practice here. So right now we're in the month of August of 2025. If a tenant owed 2 years worth of rent, we could only go back to September 2024 through August of 2025. That would be the 1 year period. So even though he owes you more rent than that, you can only go back 1 year. Now, I believe that it's fair, unless the tenant has specifically noted it on his payment, that whenever a payment is made, it goes to pay the last payment, I mean, the first payment that became due. So, for example, if a tenant didn't pay you rent in January and then in February pays you a rent check, that, unless he wrote on it February, that's going to go to the first item that was owed, which would be for the January's rent. So if the tenant owes less than 1 year's worth of rent total. So whatever the rent is, if the rent's $1,000 for 12 months, that would be 12,000. So then you would be able to ask for the full $12,000 for that 1 year period. Also, you want to make sure, for example, like cities like Los Angeles, you don't want to include any other kind of pass-throughs, for example, SCEP fees or registration fees, which you're allowed to include according to the rent stabilization ordinance. But if you put that into your notice, you're going to lose the case. Another issue that comes up is that you have to have, I mentioned, the correct amount of rent due in the notice. If you don't have the correct amount of rent, let's pretend literally in most jurisdictions where there's rent control, if you ask for 1 penny, and I kid you not, too much, you will lose your case. 1 penny. It's got to be, can you go less? Yes. And many times when the client is struggling to figure out what's owed, I say, you know what, let's just lop off another $300. This way, whatever, we're not going to be overstated. You can be understated, but you can't be overstated. One of the tricks that they're doing now is some of the municipalities, specifically Los Angeles, requires that you pay yearly interest on security deposit. Yearly interest on security deposit. If you don't pay that, that would be considered a defense to an unlawful detainer. So maybe you didn't pay it, you forgot to pay it, and what happens? We go into court, and then they're going to use that as a defense, and your notice will be incorrect because it's overstated because it should have included the fact that he got a credit for the interest on a security deposit. By the way, the interest on security deposit, there's a chart. It's on my website at evict123.com. It's in the free form section. Excuse me, it's in the legal issues section at the website evict123.com. Check it out. If your property is subject to the rent stabilization ordinance for the city of Los Angeles, get out your check right now and write that. It's not going to be much, maybe $15 or something, but whatever it is, do it now, because if you ever have a problem with the tenant, that's going to be a defect to the case. Even if, for example, the tenant created a big nuisance on the property, and is shooting up the rotunda, you file this lawsuit under the ridiculous RSO ordinance. If you haven't paid the interest on security deposit, that's considered a defect, and that would be considered a defense, even in a situation where a tenant was shooting up the courtyard. So this is somewhat crazy, but again, this is what the rules are. Let's move now to share my screen. And let's see, right there is two. Where is two? That's three. There we go. I'm going to share my screen now. And what you're seeing now, or what you should be seeing now, is a notice to pay rent or quit. This is, of course, prepared by the Apartment Owners Association. They have, of course, the best forms. And when filling out a notice like this, you can actually fill it out on the screen. It's fillable. It has to have a statement that, and I'll point it out here, that the notice, when counting days, you exclude Saturdays, Sundays, and judicial holidays. That phrase must be in the contract. If it's not, again, that's defective under state law. Also under state law, you're going to need to put obviously the individual's name who appears in the notice, who appears in your rental agreement, and anybody who pays rent or any adult who's occupying the premises whose name that you know. So you would want to put in those names right there. Obviously, you don't want to put in the names of children. You just want to put in the names of all the adults who are occupying the premises, which are either your tenants or subtenants in possession. You also have to state in the notice, and it's listed here, who to pay the rent to. That has to be an individual's name. So you can have it, for example, that the check is made payable to XYZ Apartments LLC. That would be here. But you also have to have, and I'll just write XYZ. You also have to have the name of an individual in your notice. If you don't have the name of an individual as to who to pay the rent to, your notice is defective. You also have to have the address where payment is to be made. The address could be the apartment manager. It could be a PO box, that's acceptable. It could be mailed directly to the owner. It could be a rent collection box like I have on one of my properties. That's a fair place. So you'd write the address of the property and then put a comma, rent collection box. You can also have it paid to a bank account. So you'd have to augment this form. If you are going to have it paid to a bank account, you have to state the name of the bank. You have to state your account number. You have to give an address of the bank within 5 miles of where the property is located. You have to have the hours that the bank is open. For example, Chase Bank is 9 to 5, Monday through Friday, and 9 to 2 on Saturdays. That all has to be contained in the notice if you want to have it paid to a bank account, as many people do. So you'd have to augment this notice. It's not difficult to do. Now, people say, well, can't I just say zealot to me? Because that's a very popular way of doing that. And the answer to that is no, it can't just be Zelle. So you want to have an address, or you can write or Zelle, or sometimes you have an electronic way of paying payments through some payment center, and that's okay too. But I would say, or pay to the payment center, okay? But you can't just have that. You have to have an address or a bank account or something else that you need to do, okay? Now, in the city of Los Angeles, and in unincorporated areas of LA County, as we come up here, and I'll put in a number, you have to have the number of bedrooms. Insane. You have to have the number of bedrooms this is only for LA City and unincorporated areas of LA County. You don't have the number of bedrooms in your notice, you are going to lose your case. Now, why do they want the bedrooms? Well, that's based on the fact that there's what they call the fair market value, that you can't serve a 3-day notice unless the notice exceeds the fair market value. For example, for a one bedroom, it's $2,081. So if you have a one bedroom apartment, he owes 1 month's rent, which is 2,000. You're going to have to wait to the next month. So that's why they have that there. Also, in unincorporated areas of LA County, in addition to the bedroom count, you have to state what the fair market value is. If you don't have that, so there's a chart which tells you, for example, $2,081 for a one bedroom apartment. You have to write that into the notice. And so there's just write it somewhere in the notice and this is again only for unincorporated areas of LA County, right? Fair market value for this unit is, and that's got to be written in the notice. If you don't do that, you're going to lose your case. Okay, that's just all these tricks and traps to make it go forward with it. Now, let's move on to another notice, which is the notice to perform or quit. Again, this is a notice that's from the association, and this form, I'm happy to tell you, leads you into making a correct form. Now, obviously, you don't need to have the bedroom count, but you do need to state that it excludes Saturdays, Sundays, and legal and judicial holidays. That's got to be in the notice. But basically, this notice leads you into doing it correctly, because what it's stating is that what the violation is, okay, who is the witness to that violation, when the violation occurred, and then what you need to do to correct it. So basically, I'm saying, hey, pursuant to your rental agreement, uh, only you and your wife are allowed to live there. Currently, you have 3 other adults living there. Here's the witnesses. I'm the witness, so you would put your name as the manager or as the owner of the property. This is when I determined that you guys were living there. And this was the date. And then you write what you need to do to complete that, which is get those extra people out within the 3-day period. So that's dealing with a notice to perform or quit. And for example, though, and how would you know this? But in unincorporated areas of LA County, you have to serve a 10-day notice to perform or quit. So if you use this notice and your property was unincorporated in LA County, then this would be a defective notice. You'd have to cross out the word 3 anytime you see the word 3 and write in 10 days, because that's what the county of Los Angeles requires on these types of notices. Okay. Also, if your property is subject to statewide rent control, or you're in the Long Beach area, which follows statewide rent control, you need to serve this notice. It's a beautiful notice. You served the exact 3-day notice. You filled it out correctly. You wait the 3 days. The extra people are still there. You file your lawsuit. You've lost. How is that possible? Because under statewide rent control and also under the city of Long Beach, after the 3-day notice to perform or quit expires, you do not file a lawsuit. What you do is you then have to serve a special 3-day notice to quit. And then after that 3-day notice to quit, then you have the right to file the unlawful detainer. I can't tell you how many cases I see that come through my office where the clients filed their own and it's just busted that we have to now reserve everything again. So again, everything I'm telling you now is again designed by the politicians for landlords to lose their case, for tenants to get an uphill advantage on these cases, and that you're losing thousands and thousands of dollars on this. Let me stop sharing my screen here so you get to see who I am again. Okay. Um, the next thing I want to talk about is serving a notice. And those are basically all the same. If you're going to serve a notice to perform or quit, or a notice to pay rent or quit, or even a notice to quit, they're basically all the same. You have to go over to the property, you have to knock on the door. If the tenant answers the door, you hand it to him. If the tenant doesn't open the door after you've knocked loudly, then you are allowed to post one on the door and mail one. If you have multiple tenants, for example, tenant A and tenant B, if tenant A came to the property, opened the door, you would hand two to A, two notices, make a couple of copies, and then you would mail one to B. Okay, so you handed two to A because you're expecting A to hand it to B. And if he didn't, it doesn't make any difference as long as you handed both to A and then you mail one to B, which is what the law requires. Now, there's a little known exception, which I'm hope no tenants' attorneys are listening to, and that is technically if the tenant doesn't answer the door, technically, if you know where the tenant works, you're supposed to try to serve them at their work address. So hopefully you don't know where they work, but technically you're supposed to serve it at their work address, try to serve it over there. Then if you can't find him at his work address, then you're allowed to post one on the door and mail one. Okay, so it's best not to know where your tenant works, to be frank with you. Okay, obviously you can't serve a notice by email or by text or by slipping it under the door. Okay. It's either handed to the tenant or if the tenant's not home, post and mail it, assuming you do not know where the tenant works. Failing to put all the tenants' names in the notice can create a major issue for you. Again, you want to put in the names of all the tenants and any other occupant whose name that you know is living there as a subtenant. So they should at least match the rental agreement. And by the way, the name on the rental agreement who's designated as landlord, that's the name that should be as the landlord in the notice, even if you're having it paid to somebody else like the manager. Now, for example, if you bought this property and there was an existing rental agreement, obviously that landlord doesn't exist anymore as far as you're concerned. So you would have had to have served a change of ownership where you listed who the new landlord is, be it an individual or an entity like an LLC or a corporation. And that's the name that you would include in the notice as the landlord. By the way, if you haven't done this, go over to the AOA website and take a look at their change of ownership / change of management. You have to have all the elements in that notice. If you don't, then any notice to pay rent or quit will be defective because all the elements there. So even if you bought the property years ago, and you did serve some sort of a change of ownership notice, take a look at the one that's on the AOA website and make sure your notice conforms with what the elements are. If it doesn't, no problem. Fill out a new one and just write amended notice even 3 years later because we can get to court and we can lose a non-payment of rent case because the notice of change of terms of tenancy that you put into the in your original notice wasn't in accordance with the code section. So make sure that you take a look at that. If there's never been a change of ownership or a change of management, you can ignore this. But if there has been, and you got a rental agreement from the previous owner, make sure that you've done a proper change of ownership. Okay, I've already talked about the fact that in the notice you have to have that proper language as to Saturdays, Sundays, and judicial holidays. I've already talked about the fact that you have to have the name of an individual as to who to pay the rent to, okay? And a telephone number. Some of the problems that we have is where you have an address and you leave off the address suffix. And Jeff, put you on the stand here. Do you know what an address suffix is?
Hold on, gotta unmute here. Address suffix, the just the street or avenue or whatever.
That's exactly what that is. Most people don't know. They'll say, is it street? Is it avenue? Is it court? Is it circle? And that's called an address suffix. Nobody knows that. I had to look that up myself, to be honest with you, a few years ago. So if you leave off the address suffix, like you write, you don't call it street, you just leave it blank, you know. I think it's like, let's pretend Sunset Boulevard, you just wrote Sunset. That would be defective. Or if you wrote Sunset Avenue, the sheriff's not going to do the lockout. If you don't write East Sunset Boulevard when it is east, they're not going to do it. So you have to have the exact address on your notice. And that's because even though you might get a judgment on this case, you'll send that over to the sheriff's office for them to do the lockout, and they're going to throw it right back at you. And you're basically back to square one on this thing. So make sure you have that. Now, sometimes we have a rear house. So you want to make sure that you use the address for the rear house. If the rear house doesn't have a address, then you want to write 1234 North Gardner Street, comma, rear house, just like you would write comma, apartment number 2. You leave off the apartment number, you're dead in the water. You're not going to win this case without question. Okay, so make sure that you designate it. Sometimes you'll have a lawful house that has a rear entrance to it, one address, and their part of the house is at the rear. So you want to write in your notice, 1234 North Gardner Street, rear entrance, okay, or garage unit. You've got to specify that specific unit, okay? If you don't, you will be losing your case, okay? And so make sure that it is very specific in when you're filling out that notice. Okay, let's move over to another issue, and that is we know under California law, we can't summarily reject a Section 8 tenant. We're now almost forced to take them. If anybody calls you on the phone and says, hey, do you accept Section 8 tenants? Your first response is, yes, I love them, regardless of what you really believe, because they'll hit you with a discrimination case. Now, most people think that, and I used to give this advice, that you run their credit, and if their credit is bad, then that would be a way of rejecting an applicant. But based on a law that became effective incredulously in the state of California on January 1st of 2024, you can't summarily reject a Section 8 applicant based on credit. It now goes on something called the ability to pay. So if they can demonstrate that they have the ability to pay their portion of the Section 8 rent, and usually it's a very small portion, then you can't reject them on that as well. Okay, so you're kind of forced to take them. However, as I've stated, that Section 8 will not accept tenancies that are month to month. So from this point forward, make sure that every rental agreement, regardless of who the applicant is, that you only do month-to-month tenancies. That's assuming you don't want to have Section 8 tenants. So you'll run through the whole procedure, but you'll say, hey, my procedure, not just for Section 8, but for anyone, is that we only do month-to-month. And if Section 8 won't allow me to have you rent in my building, well, then that's not up to me, that's up to them. So that's somewhat of a way to get around that. But again, if you do have a Section 8 tenant, then what's the story with regard to serving a 3-day notice? If I serve a 3-day notice, like you've explained to me, am I going to have any problems? And the answer is, let's share our screen. So it really isn't a 3-day notice. Incredulously, for if you have a Section 8 tenant, You cannot serve a 3-day notice to pay, rent, or quit. You have to serve a 3-day notice to pay or 30-day notice to quit. 3-day notice to pay or 30-day notice to quit. So what this form says is, hey, you got 3 days to pay me the rent. If you don't, I don't have to take the rent on the 4th day, but I can't start an eviction for 30 days. Another theft of landlord's resources, of course. So this is a form, again, that's on the AOA website. And you need to serve this form if you have a Section 8 tenant. But wait a second. What if the tenant in your building is not a Section 8 tenant, but you have one Section 8 tenant in a 20-unit building in any city? You name the city in California. Well, I'm not going after the Section 8 tenant. I'm going after somebody who has nothing to do with Section 8. So clearly, I can serve just the standard 3-day notice to pay, rent, or quit. And the answer is no. If you have one tenant in your building, you've got to serve this crazy notice to every other tenant. Now, let's pretend that you don't have any Section 8 tenants in the building, none. So at that point, I should be able to serve a standard 3-day notice, correct? And the answer is maybe not. And the rule is that if you have a federally backed loan on that property, a Fannie Mae or Freddie Mac, etc., it's federally backed, you got to serve this crazy 3-day notice to perform or 30-day notice to quit. And by the way, if you do have a Section 8 tenant, you have to serve an additional form with that notice, which is called the VAWA form, Women Against Violence Act, which is a form that you can get online. Women Against Violence Act, we call it a VAWA form in our office, and that has to go with this notice. If you don't have that form with the notice, you lose your case. So make sure that if you do have any Section 8 tenants in your building, you got to serve this crazy notice. And if it is a Section 8 tenant, then you also have to serve that VAWA notice. Okay? Okay. So let's pretend you got through all those requirements, okay? And you've done everything proper. You've listened to every word I said. Could there be other issues which would make you lose your case? And the answer is, oh my God, yes, there is. There are so many local jurisdictions, such as Los Angeles and unincorporated area of LA County, that require so many other requirements that you just want to pull your hair out, or, as I've been advising, just get out of the rental market because that's really what they want you to do. So I'm going to share my screen again, and I have a list here. And this is a form that I have on my website in the free form section, and it tells you what the requirements are. So let's just take the first one. In Culver City, if you serve a proper 3-day notice, within 5 days of the service of the 3-day notice, you've got to mail to Culver City Housing Division. You have to mail a copy of that notice and a proof of service to them. If you don't do it, you lose your case. Oh, and by the way, you got to send it to them by certified mail return receipt requested. And by the way, in Culver City, if you're serving a notice to perform or quit, it's got to be a 10-day notice to perform or quit. Within Inglewood, you got to send it to the Rental Board of Inglewood. Santa Monica, all notices except for rent. By the way, in Santa Monica, you got to serve, if it's not a rent notice, let's say a notice to perform or quit, you got to serve a 14-day warning letter before you serve the notice to get rid of the dogs. Who's going to know this stuff? I told you about in unincorporated area of LA County, you've got to serve that within 5 days to the Department of Consumers Affairs. And I also mentioned that if it is a notice to perform or quit, it's got to be a 10-day notice. Okay. Now let's talk about Los Angeles. Los Angeles, you also have to, as we know, upload the notice within 3 days of the service of the notice to the Los Angeles Housing Department. So you got to go to their website, create a create an account, and then you can upload it. Obviously, if we do it, we take care of all these requirements and all the uploading, etc. But I mean, this list goes on and on. Here's one for Cudahy. Cudahy. You know, Cudahy is about 2, 3 square blocks. They have these crazy requirements. So as you can see here, what I'm showing, all these municipalities, Montebello, Pasadena. Pasadena has special language that needs to go into the notice. If you don't have the special language, you lose your case. The same thing is true for West Hollywood. They have, in addition to sending the notice to the city of West Hollywood, you have to have special language in the notice or you lose your case. Maywood just came online and they have to send a copy of the notice to the city of Maywood Housing Division. I mean, it's just crazy. And then here, Costa Mesa, Santa Ana has one. Long Beach, their only thing since they follow the statewide rent control. If you're serving, for example, a notice to perform or quit, after you serve it, then you've got to serve right here a 3-day notice to quit. So again, this is on my website. Don't hold me to this. It's accurate now, but and it keeps changing and we change it. But if you've got a particular city in any of these locations, I'd go to my website and take a look at that again. It's in the free form section. Okay, could there be more? Jeff, could there be more? And I see you shaking your head. So there's other crazy requirements that you can also lose your case on. Okay, and it's this is so crazy as I go through these requirements. I served a 3-day notice for Section 8. Literally a 3-day notice and 30-day notice to pay was 14 pages of stuff that I needed to include in it. 14 pages. And I'm like laughing to myself. I put a big paper clip around it so I knew the secretaries would know which papers go. But let's take a look at this. Okay. And let's share our screen again here. Now, this is for the city of Los Angeles. In the city of Los Angeles, I don't care that the tenant owed you the money and you did everything correctly. You've got to have this notice posted in a conspicuous spot for all residential units in the city of Los Angeles. All residential units in the city of Los Angeles, you have to have this notice posted. This notice is on my website. I don't care, it's a single family home in Brentwood for $85,000 a month. You want to be in compliance with the law? This notice has to be posted. Let's move on. Again, we're just talking the city of Los Angeles. If your property, this is a 2-page notice, if your property is subject to RSO, in addition to the first notice, you got to have this notice posted if your property is subject to RSO. And if you don't have this, that's a defect for your eviction case. Now, I told you that this needs to be posted on all properties, residential properties in the city of Los Angeles. This notice here is for all RSO properties. Could they require one more? Could they? And the answer is yes. All residential properties, you have to post this one. Oh, great. I got to tell my tenant that they have the right to counsel. That's got to be posted on the property. 2, all of these, if I have RSO properties, all 3 posted in a conspicuous spot on the property. Really? Yes, because you don't want to lose your case. So you got to tell your tenant, hey, you get the right to a free attorney. Now let's pretend, for the city of Los Angeles, let's pretend that the tenant didn't see this notice. That's not your fault. It was posted in a conspicuous spot. So let's pretend he didn't. Do you know another requirement in the city of Los Angeles? And that is every time you serve a termination notice, you also got to serve this form too. So in addition to having this form up in that conspicuous form space on the property with all the others, you now have to post this notice on the property. It almost makes you want to sell your property right now. So this notice has to be posted. Okay, let's move on to unincorporate. This is that notice. Crazy. Jeff, do you know if you have these notice? Well, you probably don't have these notice permeaplacked, do you?
Do we have them what?
Permaplaque that you can buy
Oh,
them.
laminated?
Yeah.
Yeah, we do actually.
That's good. The problem is that they change these forms and you have to keep changing them at least once a year.
I
And
know it. It's
now,
crazy.
moving now to the unincorporated area of LA County, you've got to have this notice up, posted in a conspicuous spot. If you don't, you lose your case. In addition, oh my God, you have to have this one up. Again, these forms are on my website, and that's a notice of right to counsel. That's got to be served with the 3-day notice. If you don't serve this notice with the 3-day notice, you lose your case. So this notice has to be posted in a conspicuous spot. This notice needs to be posted, served with a copy of any termination notice. Well, that was a mouthful, wasn't it, Jeff? Anyway, there's more to it than this. And I'm not just doing this to uh, garner more business for myself, but the reality is these are a shotgun approach to all the requirements necessary. And there's much more than 10. And again, these are all designed for one purpose only, to allow landlords to lose their case, to allow the theft of your property by these tenants, and that's all they are. A guy owes 15 months worth of rent, and there's one you didn't pay interest on security deposits, and you're going to lose your case. There's no fairness to that. Okay, the law is supposed to be equitable, but they build in all this garbage, and that's what it is. It's garbage for landlords to lose the case. So, and again, you can go to the an attorney who's been around for 40 years. If they don't practice this area of law, you got no chance. Anyway, Jeff, I'm going to open it up to questions,
All
and we
right.
go
Yeah,
into.
thank you so much, Dennis. And yeah, we do have questions here. Just Greg in the chat. We can start here, and you can raise your hand too. Like there's at the bottom, there's the little raised hand feature. You can raise your hand if you have a question on Zoom. But Greg here, I stated in my rental agreement, I give options to pay by check, money order, or Zelle. If I accept Zelle payments in the past, if serving the 3-day notice, can I put the address and leave off the bank info?
No, you have to have, you can't, you could tell them the Zelle, but you're going to have an address or the bank number and account number.
All right. And Ed, does putting the property on a living trust a change of ownership? And do we have to notify the tenants?
Good question. Probably not, because you're not going to tell them to change it to pay to the living trust in most situations. If you're going to tell them to pay to somebody different, like, hey, pay it to the XYZ family trust, then yes. But otherwise, if it's more of an estate planning on that. So it's not really looked at as a true change of ownership. So on that basis, since the tenant is paying the same person, I don't see a problem with that. But if you did switch, for example, from an individual to an LLC, that's a different story. And now you want them to pay to the LLC, I would do that change of ownership.
All right. Ariel, if you evict someone this year and you paid the interest to the tenant this year as well, but you did not it, pay the interest 2 years ago, is that defective or what?
Yeah, it's defective because you have to have the interest paid. You can pay it all in one shot if you haven't done it for the last 6 years. You can do it now,
Mhm.
but you're going to have to do that.
And you talked about overpayment of the rent, and you said just apply it to the oldest balance due, basically, unless they say something else. And they're asking if you would have to refund it. Would there be a circumstance where you'd have to
No, there's
refund that?
there's never a refund in rent. What I was talking about is that from an accounting principle, if a tenant pays rent in 1 month, it should go to pay the first month that became owed, unless the tenant specifically writes on his check, this check is for August 2025 only.
Right. All right. Let's see. Can we correct all this requirement before we go to court? So they served it the wrong way.
No, as I always said that uh, a, a notice in an unlawful detainer is synonymous with the foundation of a property. So if you build the Taj Mahal on a bad foundation, you're going to have to tear it down. So once that is filed, you're dead if your notice was dead or these requirements weren't met.
All right. And we'll just move over to the questions on YouTube. Kevin, thanks for your question. LA City RSO, thank you so much for saying where you're at. For Section 8 tenants with small tenant portion, if the total yearly amount is less than the threshold, what do I do?
Okay, so I did a case the other day on that. The total amount is less.
Right. So basically, Section 8, the renter portion never gets to the threshold.
You're right. This is truly why the law is insane. So, for example, if the tenant share was, let's pretend $100 for a one bedroom, actually let's make it, yeah, for a one bedroom apartment, and the tenant never paid the share for 1 year, well, the tenant would owe $1,200, but for a one bedroom apartment it's 2,081. So on that basis, you can never collect the rent. The way we get around that is that we state that we're going to evict you based on failing to pay the late charge. So I'd serve a 3-day notice for a proper late charge. And if it is a proper late charge and they don't pay within the 3 days, then we got them.
Okay, there you go. David on YouTube, security deposit interest, landlords have to pay. Is that retroactive for tenants living prior to this rule?
Uh, Retroactive, what was the question?
So the,
Oh,
is it
yes.
retroactive to tenants living prior to the rule? So maybe how far back does it go that they've had to pay interest on this? I know it goes back
That
for
goes, I think the form
decades.
goes to the 80s. Let me pull that up here real
Yeah,
quick.
goes back forever. So,
Yeah, it goes back forever. So I would just, and even if the previous landlord didn't do it, you're held to the same standard as the previous landlord. Let me show you this form. And let's make this, see if I can make this bigger here, if I can. Okay, let's share it. Okay, so you can see the form now, and you can see it goes back to 1990 over here, which was 5% for that period. So depending on how long you need to have this sent. Now, incredulously, for this year, they're requiring 4.32%
yeah.
on interest on security deposit. This is insane. I can't even get that at a bank right now. But I don't know. It's just this
So
whole.
with that, Dennis, is there a way around that? Can't you prove what your interest with your bank is, or does
Yes, if you can show that the money was put into that account, then you can prove that, then you can show that I'm going to pay just what my bank charged. You
okay,
can do that. That's another option. But people aren't. It's difficult to do that. So it's before it really didn't make any difference because these figures were so small that it wouldn't make any difference. But now with 4%, that is truly insane. Um,
totally.
Get
All
rid of.
right. So Teresa in Los Angeles, if there's no on-site manager and someone goes to the building to collect rents, is it okay to only write the building address without unit or office number?
And the answer is absolutely not.
Yeah.
You have to have an address where the tenant can go. If you write, I'm going to pick it up, that is a totally defective notice and they'll throw you out of court. Good, great question and an easy answer.
That's one of those mistakes that the Asesian made, right? Or Asajian, however you say his name, like he had the tenant's unit as the place to make the payment, right?
Absolutely.
Yep. So like they were, I'm sure what the guy meant was, yeah, I'll go pick it up at your place, but yeah. All right, Admin Gardner. You mentioned all tenant names must be on a notice. What about minors or known unauthorized occupants?
Right now, if it's a minor, you're obviously not putting their name on the notice. But if you know the name of an unauthorized occupant, I put that too. I would just put after his name unauthorized subtenant.
Hmm. All right, let's see.
We had another one come in from the chat.
Yeah, I'm looking at the chat here. For the interest, can we add it to the credit on their rent instead of sending a check?
And the answer is yes. I would send them a note saying you only owe me X amount of dollars because I'm giving you a credit
Yeah,
on that.
just
But you know what? I think it's just better for at least for us attorneys that you write your own check so I can prove that you sent it to them.
okay. Should I just cancel the upcoming court date since we have a few issues that we need to address before we move forward? And so, yeah,
If the trial is coming up quickly, and I don't know who your attorney is, if the trial is coming up quickly, most of these cases settle. So if it's coming up in like 2 months or something, that's another story. Uh, but if I would go there at least to the first court appearance and see if you can settle the case, most cases do settle. We settle, I would say, instead of like going to a jury trial, 90% of our cases, 95% of our cases.
all right. Yeah, here in the chat on Zoom, Let's Go 2025. I have collect several obvious evidence of violations of the lease agreement. They have 3 dogs, 5 occupants instead of 2. Can I come to your office to start with a Section 8 tenant now? It's disruptive of other occupants and neighbors, etc.
Yeah, you don't really need to come. You could just call us on our phone number, which is on the screen there, and we're happy to take that case in. We'll make sure that we comply with the correct notices, the VAWA form, the Women Against the Violent Act. Yeah, just give the office a call. We're happy to assist.
Yeah, that one, like I know in Oakland, just recently, there's like 17 cases thrown out because the Oakland's, the City of Oakland website has the outdated VAWA form. So, so 17 different cases thrown out. That's just recently. So you really need to make sure you're using the updated one as
Yeah.
always. But anyway, this is a good question from Jana. On a 3-day notice, can we use a PO box? I don't want my tenants to know my home address.
And the answer to that is yes, you can do a PO box, but the tenant, under the rules, has to have a physical address where they can serve you with legal process. So that should have been either in your rental agreement, or if you became the owner, that should have been in your change of ownership. But in terms of payment easily can be made to a PO box.
Yeah, you just let everybody use your home address, right? All your
Oh,
clients?
no problem. Yeah, come on over if you can get through the gates.
All right. So Jay Hyun is asking, does the interest for the security deposit owed apply to all properties or just certain types like RSOs?
It just applies to RSO
Great
properties.
question. Great question. Thank you for clarifying that one for everybody. All right, Johnny on YouTube. Let me pull this over here. All right. What are requirements for new JCO requirements for single family residents? Are they under RSO requirements and limited to 3% rental increase?
Okay, first of all, if you're JCO, you do have to register that. So JCO stands for the Just Cause Ordinance, and that's every single residential property, single family homes, every single residential property that is not RSO. If you're not RSO, then you're JCO. You need to register that once a year. You're going to need to pay $31.05 currently. Make sure you get it registered. Make sure you send a copy of the registration to your tenant. Now, are there notices to be posted? Yes, that first notice that I showed you, which says, protection notice to tenants, and also the one, the right to counsel, those notices need to be posted. If in terms of rent increases, the city of Los Angeles has nothing to do with JCO properties as it relates to rent increases. So if your property is a JCO and it's a single family home, townhouse, or a condominium, it's unlimited rent increases whenever you like. If your property is, let's say, an 8-unit building, but it's not under RSO, because let's pretend it was built in 1990, then that building would be subject to statewide rent control. And if it is subject to statewide rent control, currently it's 8% because it's 5% plus the CPI, which for the Los Angeles area is 3%.
All right, Javier, I evicted a tenant to do major work on the unit. if I decide to use it for personal use, what do I need to do to be within the law?
Well, if you evicted a tenant based on statewide rent control, which allows you to evict a tenant based on major renovation, you do have to renovate the unit, but there's no requirement that you rent it to somebody else. You can live in it yourself. You just have to have done the work.
All right, Martin, do the postings in LA City, the Renters Protection Act, the RSO, number 2, number 3, right to counsel, need to be printed in color? And can they be reduced in size so that they fit in the board?
The answer is they don't have to be printed in color, and you can reduce them in size as long as they're legible.
Great. Hey, isn't that nice to know? Okay. All right, let's see. Silverback on YouTube. Thank you for all your information. In San Diego, it's a duplex. If we serve a 3-day notice, include the payment to Venmo. Um, how do the tenants pay rent or to contact us by phone to pick up the past due rent? Will you be addressing buyouts in lieu of eviction?
Kind of a shotgun question there. Uh,
Yeah,
if you're going to have them pay by Venmo, you still have to, as I said, state a physical address where payment can be delivered to, or a bank account number, or even a PO box. You just can't say Venmo. There was something also about buyouts. I think we're going to leave that to a different a different time.
right. All right, Nancy, I didn't catch everything regarding the security deposit. Now remember, a lot of this, everybody's asking about security deposits right now. Dennis did the security deposit crash course on AOA USA, so go to the YouTube and watch that one for sure. But here I'll keep reading. I'm currently in the process of evicting a tenant for nuisance. Am I required to show them the interest earned at year or when? I have all forms posted, but some have disappeared. I took pictures
Well,
that I
if
posted these. Do I need to keep posting? I'm like,
I would keep posting, especially when you're in the middle of a lawsuit, okay, and take pictures of it to show. If you didn't pay interest on security deposit, that could be a problem. So, but the issue is, does the other side know? And the also, um, is the case going to potentially settle anyway? So it all depends when your trial date is.
yeah. So Kevin, do all cities require landlords to pay interest on deposits?
The answer is no. There's a couple. I'm thinking someone told me Pasadena. Do you know if Pasadena has that?
I'm not sure about Pasadena, but I
But
wouldn't
I
be
know for the city
surprised.
of Los Angeles, they do require it.
Yeah. Okay. For interest on security, does that apply to San Bernardino County rentals? And the answer would be no, just based on what we know. And I think there's just one or two more here. Okay, there are 4 tenants on the rental agreement, and then 2 people leave. Tenant brings 2 more to replace the ones who left. Can you request a rental application for the 2 new people that coming into the unit? Can you
The
evict
answer
them
is,
if they do not want to comply by filling out the application? It's
and the answer is
C of LA
absolutely.
RSO.
Yeah, absolutely. They can bring in replacement tenants, but they got to first to let you know. Otherwise, it's a violation of the rental agreement.
So
So
that's
they have to,
unauthorized
if they don't want to
occupant.
fill out an application, then they're not in compliance.
Okay, so those are unauthorized occupants.
Yeah, they would be considered unauthorized. You
Mhm.
would have had to approve them, but if they just moved in, they're not giving you that option.
And if they took rent from them, then they basically approved them, right?
Yeah, if you take rent from a stranger, you just created a tenancy.
And then what's the timeline? Like from the time that they recognize that, oh, these people are here and they're unauthorized, is there a window?
If you're talking about raising rent for additional, the example wasn't additional, it was the same amount. But let's pretend you had 3 people there and they
Oh,
brought
that's
another
right. Yeah.
in. You have to, once you know about it, you have 60 days to do a rent increase in the city of Los Angeles, assuming that's what you want to do, raising the rent 10%.
Okay. And court date is in mid-October, so sorry I didn't include that information. So can I just start again? What would you recommend? So
It all depends. I'd have to see who's on the other side on this kind of a case. Is it just in pro per without an attorney? So there's many factors. It's unfortunate you already have a trial date, but that file trial date's kind of far in the future. I'm surprised. So I'd have to evaluate it. I probably, without knowing any other facts, I'd probably lean to start it all over again.
Mhm. All right, let's see. We're right at 11 here. You want to take one more?
One more, young sir.
Okay, here we go. Let me say, yeah, everybody's asked questions, the same other questions. Isn't it time to start a counteroffensive? How difficult would it be to place on the ballot a proposition to eliminate all rent control laws and ordinances?
The issue whether it would pass or not, and I doubt it would, certainly in this state, you'd have every tenant, and there's more tenants than people that have property rights as an endearment for themselves. But I mean, you know, these cities and states are crazy. We right now to politicize. We've got a communist that's going to be the mayor of New York. So, I mean, who knows where this is going with this? And it's a very disheartening, and that's why we really have to know our rights, stand on our rights, and enforce our rights. And we're running a business here, ladies and gentlemen,
On the
and
front desk, Wayne.
we're running a business here, so we really need to make sure that that we do everything correctly.
Absolutely. And I appreciate you because you help us with that like big time by just about every month you come on and sometimes you're at the in the in-person seminars and even just last week all day long at the trade show. So we really do appreciate you.
And I appreciate the association. I appreciate you, Jeff.
All right. And everybody, thank you for joining. I know you guys care, and we just want to help you to avoid the landmines. So I hope this was helpful. Always, always read this man's legal Q&A. If you're in LA or Orange County, he has a different one for each of those areas. And then if you're in San Diego or Northern California, we have other attorneys that are there. And yeah, there's a thumbs up. Anyway, thanks, guys. We really appreciate it. Take care,
And,
everybody.
and don't forget my show on Saturdays. Hit
Oh,
my
that's right.
website every 3 p.m. on Saturday. Thank you,
Okay.
guys.
Thanks. Take care.